I would ask for 5 minutes.
Thank you. Jesse.
May it please the court, opposing counsel, Donald Gallick on behalf of appellant Robert Schutte. We have 4 assignments of error before the court, 2 involving the legal malpractice claims, 2 involving the common law fraud claims. The litigation history involving Mr. Schutte is obviously substantial. You can see that from the briefs, and if you looked at the file, it's quite a bit. However, in this case, there's really allegations of legal malpractice occurring in, we'll call it the real estate case, and then legal malpractice occurring in the Summit County Sheriff's case, and we're saying the common law fraud occurred in the real estate case. Now we have this one issue, and the court can see the case law is a little muddled across Ohio, about whether you can have a common law fraud claim stand alone. I'm sort of going out of order here to try and take the easy issues first, but this would go to assignment of error 4. Can you have a common law fraud claim stand separately next to a legal malpractice claim? Some courts say that you can, some courts say that you can't. I don't think this is uniformly decided. However, as I point in the brief, there's really 3 distinct torts that we're alleging. Legal malpractice in the real estate case, legal malpractice in the Summit County Sheriff's case, and then common law fraud. And they are separate actions. Now we go into the other issue of the cognizable rule versus the termination rule. And there's a very interesting case. I think I cited it. It's North Shore Auto versus Western Herd. In that case, they say if there's some difference in the date between the cognizable rule and the termination rule, you use whatever date is the latest. So that's very beneficial for us. Except this is slightly distinguishable. This is saying what happens if there's 2 different dates from 2 separate termination dates. Because Mr. DiCello sends an email saying, I'm done with you clients immediately. And he says immediately. And during the deposition, I ask him, do you have to ask a court's permission to get, to withdraw from a case? He said no, he's never heard of that. You can just fire a client unilaterally and you're just done, and that's the day that you're done. This August date, I think it was August 4th, 2015, that was the termination date that the trial judge used in granting summary judgment, saying, well, you're beyond 12 months statute of limitations. I don't want to hear about the statute of limitations for common law fraud because they all are one tort. Basically, you commit fraud within a legal malpractice, you get a much shorter statute of limitations rather than the 4-year fraud statute of limitations.
Counsel, did
please.
I read something in the brief that was taken from Mr. Schutte's deposition, and certainly I'm sure you'll correct me if I'm wrong, that while he was being deposed, he also recognized that email as being the termination of his relationship with his attorney?
Well, he might have made some statement about that. Obviously, Mr. Schutte's not in a position to make legal judgments.
I agree.
And as the court knows, I'm asking Mr. DiCello about legal questions, and actually his counsel says he can't answer legal questions. And I said, well, I think he can. He's a licensed attorney. I would hope that Mr. DiCello knows something about the law and can answer legal questions. Mr. Schutte certainly says, yeah, I got that email. And yeah, I thought that he was done with the real estate case, which is good because Mr. DiCello committed fraud. He said there was an agreement to sell the house. There was a motion to enforce the judgment to try and force Mr. Schutte to pay $200,000 for a house that they never saw, his family never looked at. They never even been inside of the house. I mean, that's ridiculous. Now, so you could say that August date is effective for the termination as to real estate case. But again, I would say a court has to have some say in that. I mean, if we can just fire clients unilaterally, and I can say, forget what you guys say. I mean, if that's the rule, I would like to know that, because I could certainly get rid of my desk. I got a lot of cases on my desk I'd like to not have them. But I thought you had to go to a court and ask them. But he says no. Mr. DiCello says no, I don't have to, it doesn't matter what the court says. I can just get off any case. He says he can get off of a case if they reject a settlement. Hey, what about this settlement? I don't like it. Well, I'm done with you. I'm effectively off the case immediately. Mr. DiCello gets subpoenaed to this motion to enforce this fraudulent settlement. He's served with a subpoena. He files a motion to quash. It's not ruled upon. He goes, I don't have to honor that subpoena. This is a licensed attorney. Yeah, I was served with a subpoena, but I ain't going to that. I don't have to do that. I filed a motion to quash. I asked him at the deposition, I think it's in the brief, Was that motion to quash granted or not? Well, I'm not sure. I don't know if it was granted on the docket or not, but I'm not going. You know, oh, okay. I didn't know that's how that worked. I mean, I'm learning a lot of new legal principles here in this case. And then something else we have to get into, you have a retainer, initial $25,000. Then he says, well, to go to trial, I'm gonna need another $125,000. And oh, by the way, if we go to trial, I have a contingency agreement of 50%. 50%, that's like half. 50% contingency agreement, and if he goes to trial, he's gonna need $150,000. Apparently that's a hybrid agreement that I've never heard of. And then he's asked, well, he just said, I'm done with your case, the first case, then second, the Summit County case, he filed a motion to withdraw and actually waited for the court to grant that. Do you have to give a refund? Do you have to give an accounting of any leftover retainer? I'm not sure. I don't know what the ethics rules, as he said. He doesn't, again, I guess you can't expect every lawyer to know that there's the rules of professional conduct which superseded the code of professional responsibility. But I'm repeatedly asking him, is that what those are really called? Yeah, they're the ethics rules. He has no idea. Again, I would say if I had asked a judge, are there any guidelines you have to follow? Yeah, it's the judge's regulations of ethics. They're like, well, you mean the code of judicial conduct? I mean, it's a little disturbing. There was an expert report filed in this case by Tony Dalianis. He found that malpractice occurred on multiple reasons on multiple cases. But because we had this one termination date, the trial court took that one August date and said that knocks out, that sets the 1-year statute of limitations on both legal malpractice claims and the common law fraud claim. And we think that that's error. However, I have to concede that there's a discrepancy in the case law. In some areas, I think it's very, it might not just be murky, it might be non-existent, as to what do you do when a lawyer commits malpractice in case A, leaves representation, but is still representing you in case B. It's not as easy like these cases it says, is it the cognizable rule versus the termination rule, because you have two different termination dates. And how does that work? If it was simply cognizable rule versus termination rule, then we might benefit from that because the North Shore Auto case says you use the later date. I'm asking the court to use the later date when there's two different dates of termination of representation. However, I'm saying that I don't know if there's a real case that I can assert other than asking you to extend the holding of North Auto, where you have a situation where lawyers committed malpractice in multiple cases on behalf of the same client. Assignment of error 3, I think, is interesting because the trial court said, well, common law fraud, even if we were to look at that, there's no evidence that Mr. DiCello actually got a benefit because his fraud was exposed, and alleged fraud was exposed, and he never got the $200,000 house sale, which I assume he would take 50% contingency on. However, I cite a case, I think it's TR, I'm trying to remember what it was called. Oh, it'll come to me, but it's an Ohio Supreme Court case, Russ versus TRW Inc. There's nothing in there where the tortfeasor has to actually receive the benefit. I mean, there's many situations where fraud would cause a loss to the victim, and the value wouldn't actually transfer to the fraudulent perpetrator. I mean, you can imagine someone counterfeiting a check to buy a Ming vase or whatever, and as the transaction goes down, the police show up and you drop the vase, and well, there's no fraud claim against him. The vase is broken. He never got the vase for his fraudulent check. Well, a tort was committed, fraud was committed, there was an intent to deceive, and that intent to deceive caused a pecuniary loss to the plaintiff. And that's what happened here. Mr. Schutte incurred a financial loss. He had to hire a new lawyer. He had to appear at a motion to enforce settlement. He has litigation going on over and over and over again. Much of it can be directly, there's a causation link to Mr. DiCello's actions. But you say, well, DiCello didn't actually get the benefit of the house. The fraudulent house sale never happened. Mr. DiCello never got his 50% contingency of that house sale. So there's no common law fraud. Well, that's a new element. You won't find that element in Russ versus TRW Incorporated. And I'd ask the court to make an issue of law that you don't have to actually prove that the fraudulent perpetrator actually received the benefit. We should be focused on the loss of the victim, not the benefit of the bad actor. If there's no further questions, I'd ask to reserve the balance of my time.
You have 5 minutes.
Mr. Reed.
Thank you, Your Honor. May it please the Court. For the record, my name is Orville Reed, and I represent the defendant appellees in this matter. In the house cleaning matter, I would like to point out to the Court that on page 2 of my brief, line 5 from the top, I cite to a revised code 2305.11, and that should be 2305.09. And as soon as I get back to the office, I will fire my secretary. May I please?
I hang out.
We're a dime a dozen, Your Honor. Good
That's right,
secretaries are
you're right. I
valuable.
was going to say, don't do that.
May it please the Court. In the complaint that was filed in this action that started this case, in paragraph 7, plaintiff alleges as follows. Defendants represented plaintiff Robert Schutte in 2 Summit County cases and plaintiff Susan Schutte in 1 Summit County case. Defendants were permitted to withdraw from those cases on September 11, 2015 and October 5, 2015. Therefore, this complaint is being filed within 1 year of the end of legal representation. Summit County is the proper venue as both cases occurred in Summit County Common Pleas Court. I want to point out to the Court, it sounds like a very defensive pleading and also argues law. But apart from that is the fact that what counsel is arguing in his pleading, paragraph 7, is that the statute for limitations does not begin to run until the court issues an order saying you can leave the case. And that is not the law in the state of Ohio. And the controlling case law is a 2006 decision out of the Supreme Court of Ohio, Smith versus Conley, that is cited probably ad nauseum in my brief, but it's cited at least once there, for sure. In Smith versus Conley, the Supreme Court addressed this issue head-on and said that whatever the local rules may be for getting out of a case, those are not dispositive of when the statute of limitation begins to run in a legal malpractice case. The statute of limitation in a legal malpractice case begins to run when the relationship between the client and the attorney is terminated. And it's terminated by some act of the parties. It's a consensual relationship. When one party withdraws its consent to that representation, in fact, for the statute of limitation purposes, that relationship is terminated, and that's when the statute of limitation begins to run. And this court has held on at least 2 occasions, probably more, in Roof versus Belfast, a recent decision by this court, 2013, and also Brown versus Johnstone, when most of you were in high school, 1982 decision of this court, where the court said, in some cases, as a matter of law, we can tell when that relationship is terminated. And it's terminated because by conduct or by actions of one of the parties, it is very clear that the client has lost trust in the lawyer, or the lawyer has lost trust and confidence in the client. And as a consequence, as a matter of law, we can say it's terminated at that point. And I would respectfully submit to this court that it could not be clearer from the email sent by Mr. DiCello on August 3rd, 2015, that he was terminating the relationship between himself and the Schuttes, plural, because of the fact that he felt that he had been lied to, and that he had been treated poorly, and he had been sent out on a mission, which in fact they now claimed he had no authority to engage in. So I think it's clear as a matter of law, the judge was right in saying the termination occurred on August 3, 2015, and you had 1 year from that date to file your malpractice case, which wasn't done. The lawsuit was filed, of course, 13 months and 4 days after the termination of that relationship. But not only that, the front and center in the lawsuit against Mr. DiCello is the fact that the lawsuit is brought because of the fact that he lied about this real estate transaction. That is the whole subject of the email on August 3. So in other words, the cognizable event occurs at the same time the termination occurs, and that's on August 3, 2011. So notwithstanding, and I agree with counsel that the period of statute of limitations for a legal malpractice case under 2305.11 runs from the later of the termination date or the cognizable event. In other words, was there one event that would put a reasonable person on notice that the relationship is ended? Or, excuse me, that an event has occurred that would give rise to a legal malpractice case. So as far as that's concerned, those events occurred at the same time. That's August 3, 2015. I'm quitting. I don't want to be your attorneys anymore because of the fact you set me up on this transaction and now you're saying you didn't do it. We don't have the sort of relationship that I consent to any longer, and withdrew from the representation. And that is the date, according to Smith versus Conley. And I hate to fall back on a mere Supreme Court case, but that's the date that the Supreme Court says that's when the statute of limitations begins to run. Now, we are now told that there is a discrepancy between the 2015 04 case, which involves the real estate, Tim Drive, and the unapproved highway, and also the 2017 case, which involves Mr. Schutte's dispute with the sheriff's office. In the brief that was filed in opposition to our motion for summary judgment, this is what is said. This is all that is said in terms of legal malpractice. This is on page 6 of the brief filed in opposition. In all fairness to Judge McCarthy, counsel asserts that even if the legal malpractice claims were to fail, the common law fraud claim could stand alone given legal precedent cited above. There was absolutely no argument at that time raised in the lower court, in fairness to the judge, that said, well, there's a distinction between the cognizable event on the sheriff's case vis-a-vis the real estate case. And our position was he withdrew from the representation on August 3, 2015, stated the reasons, and withdrew from those cases. Now they're arguing for the first time up here, contrary to this court's recent decision in Gorby versus Aberth, and as well as a recent case decided by the 10th District Court of Appeals, Hudson versus American Chambers Life Insurance Company. You can't raise new issues in the Court of Appeals for the first time, which I heard questions about that earlier this morning. It can't happen. It's contrary to the process. If you're going to tell a judge she's made a mistake, you should tell that judge. You shouldn't be telling other people. You should at least be making the argument to that judge that this is what the law ought to be, and if she doesn't agree with you, you take it up. But to come up to the Court of Appeals for the first time is inconsistent with our process, and it's inconsistent with good jurisprudence. Finally, the fallback position, of course, in this case, is that they've got a separate cause of action for fraud. Forget about the one-year statute of limitations. We have been defrauded. And it all goes back to the real estate transaction, where we are told that the lawyer went out and tried to buy the Fitzgibbons property for the sum of $200,000 when he, in fact, had never been authorized to do so. He was on a lark of his own, as it were, to settle this case. Well, that is really the essence of malpractice, when a lawyer goes beyond the bounds of what he has been authorized to do. That's the very essence of it. And that's what Judge McCarthy basically was saying, Judge McCarty, excuse me, was saying in the lower court. This is the essence of malpractice. It's not fraud. And I would go back to what basically, in the Adriano's case, it's an old case that goes back to the 50s. And basically it says, when we're trying to figure out what the statute of limitations is, we look to the essence of the claim. And the essence of the claim here is that you exceeded your authority as a lawyer. That's malpractice. That's malpractice. There's no fraud here. And I would also, in the Adriano's case, of course, is a Supreme Court decision which is often cited and relied upon. We deal with the essence, not with the form of pleadings. The other case that's interesting is a case that's often cited, Crosby versus Beam, because it's often cited in shareholder disputes. And in that case, the plaintiff wanted to get around the 4-year statute of limitations. There he had a 4-year statute. That wasn't long enough for him. He needed a longer statute of limitations So he said, I've been defrauded, and the statute of limitations for fraud begins to run when the fraud's uncovered. And in Crosby versus Beam, the court said, hey, look, you've got to plead with particularity what the fraud is. This is just pleading. And they said, you didn't plead it, it's not there, and you're bound by the 4-year statute of limitations of 2305.09, 4-year limitation on breach of fiduciary duty. You can't get into a longer statute of limitation because he didn't plead fraud. And in this case, there is no fraud. There is no misrepresentation made to the plaintiffs. There was no misrepresentation made to them. They can argue he exceeded his authority in telling the Fitzgibbons they might have a real estate possibility, a sale, but they never made any misrepresentation to the plaintiffs. As a matter of fact, the day that it occurred, they crowed about the fact, hey, we can get this house for $200,000. There was no lying to them, and that is the very basis of their offense now. They're offended because of the fact he did this. He told them on the very day he did it. Where's the fraud? Where's the misrepresentation to them? Furthermore, where's the reliance that these people have? There is none. They didn't rely on that misrepresentation. They immediately scolded him and said, you don't have authority to do that, but of course tried to keep him in the case. And I said, no, this is what we talked about. And he withdrew from the case on that basis. But if you look to the Crosby case, where they said the pleadings don't match up, in this case the evidence doesn't match up with fraud, wholly apart from the fact, as courts have repeatedly stated, the Galat case out of 12th District, it's Montgomery County Court of Appeals, I've cited it, as well as Blackwell versus Gorman. All of these things arise out of the attorney-client relationship, and they fall under the 1-year statute of limitations for malpractice. The Galati case also makes the point that unless the lawyer is trying to get something for himself, then it's not fraud, it's malpractice. So there is just a plethora of case law that exists out here that would, I think, suggest that Judge McCarty was absolutely correct in her decision, and that this court should affirm the decision of the lower court. And I appreciate your time this morning.
Thank you. Thank you, counsel. You have 5 minutes.
Thank you. Let me say this, as to the raising new issues. I mean, I think what the new issue was is there was any risk of the second case being dismissed on statute of limitations grounds. Didn't even think that was an issue because the complaint was filed on 9/7/16, and Mr. DiCello didn't file even a motion to withdraw until September 14th, 2015. So he didn't even file his motion to withdraw. The motion to withdraw was filed less than 1 year. It wasn't granted until October 5th of 2015. So I don't see how there would be any reason for us to argue the statute of limitations in the lower court as to the second case. Courts prefer to have combined litigation. I mean, this court could say that these cases should have been brought separately, should have filed a malpractice complaint on the real estate claim, file a separate complaint for malpractice on the Summit County Sheriff's claim, but that doesn't seem to comport with general jurisprudence in the state. As regards to the intent of fraud, I mean, Mr. DiCello was trying to get a 50% contingency of a real estate sale, and he was duly subpoenaed and said, I can't, I'm not showing up for that. It admits that he doesn't know if his motion to quash was granted. It wasn't granted, and he just dodged the subpoena. Well, he didn't dodge it, he was served. The reason is because he was engaged in this fraud. There's emails that were produced at the motion to enforce settlement. The emails are from the Schuttes to DiCello saying, well, why would we want to buy this house? Who told you that we're going to pay $200,000 for this house? And then in Mr. DiCello's deposition, when I asked him, well, where did you have this authority? Oh, it was over the phone. Oh, I don't have any documentation of them saying that I could do this. I don't have any emails. I don't have any written documents of this. But believe me, I have full authority, and we just did this all over the phone. We're trying to negotiate a $200,000 real estate claim where your real estate settlement, where your clients never walked into the house, and you don't have a single thing in writing. You don't have a single email, a single letter. You have Mr. DiCello is trying to get a 50% contingency of a real estate sale. That's fraudulent intent. The trial court is correct that he didn't actually get that money, which is why maybe he was trying to rely on getting the $125,000 retainer. But again, in the TRW Incorporated case, the Supreme Court had no element of actual benefit going to the tortfeasor. It's the loss incurred by the victim that really involves common law fraud. I think that the record shows that Mr. DiCello committed multiple acts of malpractice, as our expert report indicated, and there was common law fraud. This court might say that the 4-year statute of limitations does not apply when it is tied to a legal malpractice claim. But at the very minimum, the legal malpractice claim in the Summit County case, he didn't even file a motion to withdraw until about 11 and a half months before the complaint was filed. So that isn't a new issue. It's something that shouldn't even have been in the summary judgment order. If there's no further questions, I'd like to thank the court for its time.
Thank you.
Thank you, Your Honor.
The court will take the matter under advisement and issue a written opinion, and it will be sent to both sides as well as released on our website and the Supreme Court website. Thank you, Judge.
Thank you, Your Honor.